You think your book title is protected, that no one else can use it, that it's legally yours. It's not. Under US copyright law, titles are not eligible for copyright protection. Someone can publish a book with your exact title tomorrow, and under copyright law, there's generally no legal recourse available to you. Today, I'm going to tell you what the law does protect, why most authors are guarding the wrong asset, and how to start building something that's actually worth money. Now, stay to the end because the third step is the one that turns the book into the business. If we haven't met yet, I'm Ellie Shefi, attorney, strategist, and founder of Made to Change the World, a publishing house for mission-driven leaders. I'm a 12-time #1 international best-selling author with over 30 years of experience across law, business, education, and advocacy. My background is in intellectual property, and confusing title protection with copyright protection is one of the most common mistakes I see authors make. Under US copyright law, titles, short phrases, and names are not eligible for copyright protection. The Copyright Office has stated this clearly, and courts have confirmed it repeatedly. Why is that? A title is a label. It points to the work, but it's not the expression of the work itself. And copyright only protects original expression, the actual words you wrote, the way you organized your ideas, your specific stories. That's what gets protection. The few words on the cover do not. Now, I know this feels wrong. You spent months choosing that title. You tested it. You built your marketing around it. And now I'm telling you that someone else can use it tomorrow? That's the reality. And the reason most authors don't know this is because nobody tells them. They assume that the title is protected the same way the manuscript is, and it's not. And that assumption costs people. If you think this is rare, go search Amazon right now for any common book title. You'll find multiple books with the same title by different authors. The Power of Habit, Start with Why, Miracle Mindset. Titles get reused all the time because there's no legal barrier against it. Now, once you understand that, you stop guarding the wrong thing and start protecting what the law actually lets you own. Now, your manuscript is generally eligible for some level of protection under copyright law the moment you write it down. Your specific words, your stories, the way you organize your ideas, that's copyrightable. And I made a whole video about how to register that properly. I'll link it right here. But your title, copyright can't help you. Here's what can. If your book title is also the name of your methodology, you may be able to protect the methodology name through trademark. But let me be clear. You're not trademarking the book title. You're trademarking the brand behind it. A trademark protects what the law calls a source identifier. In plain English, that means that anything that tells the public this comes from this person, your brand name, your logo, your series name, and the one most authors overlook, the name of your methodology. Now, let me be specific here because people mix up these terms all the time. Your methodology is your process. It's the step-by-step system that you teach. Your framework is the structure you organize your methodology into. Sometimes people use methodology and framework interchangeably, and that's fine in conversation. But for intellectual property purposes, what matters is the name that you give it. The name is what you trademark. The actual steps and ideas inside your method, you can't copyright those. Under copyright law, processes, systems, and methods of operation are not copyrightable. That's Section 102B of the Copyright Act. But the name you put on your method, the branded identity of your system, that may be eligible for trademark protection. And if it qualifies, that's the piece that you can own. When someone sees Chicken Soup for the Soul, they're not reading a title, they're recognizing a brand. That's trademark territory. Same applies to the 5-second rule. Those names function as source identifiers, and that's what the law protects. So here's what I want you to take away from this section. Your title is not the asset. The name of your methodology is, and that's where your attention should go. This is where most authors stop thinking. They see the book as the end product, but the book is just the beginning. Now, let me say that again because it matters. The book is not the end. It's the beginning. It's the front door. And the best books, The ones that really build businesses, they're the ones with a named framework inside them. A copyrighted book is a fixed asset. You own the specific text. But if someone publishes a book with the same title under their name, copyright law gives you no recourse on the title itself. But a trademarked methodology, that's different. That's licensable. That's something you can build an entire business around. Now think about what that looks like. A certified coach who licensing your methodology from you. A company that adopts your framework for internal training. A speaker who pays for the right to teach your system. That's recurring revenue. That's business value that goes far beyond book royalties. Recently, one of my authors came to my best-selling book bootcamp with years of experience, but no clear framework. She knew her subject deeply, but hadn't actually organized it into a named method. We changed that. She said I helped her figure out what her actual methodology is and what her business is actually based on. We worked together to structure her methodology, to name it, and to build the book around it. Her book became a #1 international bestseller and has opened the door to speaking and media opportunities, aligned partnerships, and a global client base. The reason it had that kind of impact is because it was built on a named, structured framework. The book was powerful because the framework was clear. That's what I want you to see. A book with a clear framework is worth more than a book without one. The framework gives the book its authority. It gives readers something to remember, something to talk about, something to refer back to. And when that framework has a name that you can trademark, wow, the book becomes the front door to a much bigger business. And if you're wondering whether someone can steal the ideas inside your book, I covered that in an earlier video. I'll link it right here. The short answer, yeah, ideas are not copyrightable, but your expression is. And your framework name can be trademarked. Quick question for you. Do you have a named framework in your book? Or is it still just content without a label? Drop the name of your framework in the comments if you have one. And if you don't have one yet, drop not yet and get to work. I want to see where everyone is. And if this is your first time here, this channel is for mission-driven leaders, coaches, consultants, authors, and speakers who want to turn their expertise into a book that actually builds their business, their brand, and their legacy. If that's you, welcome. I'm glad you're here. Be sure to subscribe and hit the bell. I've got a full library of helpful videos on how to write, protect, and publish your book the right way. Thanks for being here and supporting this channel. Okay. So how do you protect your framework? Here's what you can do, and you can start today. Step 1, name your framework clearly. If your book teaches a method, a system, a process, give it a name. Now, not a generic name, but a specific branded name that people will associate with you. Something that when someone hears it, they think of you and only you. StoryBrand is a great example of a name. My communication framework is not. Profit First is a great example of a name. My financial method, it's not. See the difference? One is ownable. The other is a description that anyone could use. The name should be distinct, memorable, and connected to your work. You want people to hear it and immediately associate it with you. If you're not sure how to get there, that's something I work on with my authors at my best-selling book bootcamp. It's one of the first things we do because everything else builds on top of it. You can find the link in the description below. Now, step 2, start using the TM symbol now. This is the step that most people skip because they think they need permission first. You don't. The TM symbol tells the world that you're claiming this name as your brand identifier. You're putting everyone on notice that you consider this name your intellectual property. You don't need federal approval to use TM. You just need to be using the name consistently in commerce. On your website, on your book cover, on your course materials, on your social media. Consistent visible use as a brand, that's the key. Now the R with the circle around its symbol is different. That symbol is for registered trademark, and you can only use that symbol after the United States Patent and Trademark Office grants your application. But the TM is available to you right now, today. And step 3, File your trademark application with the USPTO. The United States Patent and Trademark Office is the governmental department where you'd file your trademark application. Now, filing costs a couple $100 per class that you're applying to. Submitting your application puts your claim in the federal record. That's important because even before your trademark is federally registered, the act of filing creates a public record of your claim. You're building ownership. You're building a paper trail. And you're building an asset that increases in value every year you use it. Most authors never think about trademark filing. They finish a book and they move on. They collect their royalty checks and they wonder why the book didn't change their business the way they expected. But the authors who file for trademark protection, the ones who build a trademark portfolio to train teams, they're the ones whose books are still generating revenue years later. Now here's the trap. Many authors get so focused on protecting their book title that they spend time and money trying to get a copyright that the law simply won't grant. They lose. They get frustrated. They think the system is broken. And this goes double if you've been through a publishing experience where your rights weren't protected. If a previous publisher didn't help you think about protecting your IP, didn't help you name your framework, didn't help you build protectable IP, that's exactly why you'll want to do it now. Protect your methodology name. Protect your framework. Protect what functions as a brand identifier. That's where legal protection gives you real power. So let me bring this all together. Under US copyright law, you cannot copyright a book title. You cannot copyright the ideas or the unnamed process inside your book. But the name of your methodology may be eligible for trademark protection. And a book built on a named protected framework is worth more than a book without one. That's what turns a book into a scalable business. Whether you're writing your first book or rebuilding after a publishing experience that didn't go the way it should have, build your book around a clear framework, give it a name, and protect that name. If you're not sure where to start with any of this, I have a free masterclass that walks you through exactly what it takes to write and publish your book the right way. That link is in the description below. And if you're ready to go deeper, at Made to Change the World Publishing, we guide you through IP strategy, copyright and trademark guidance, framework naming, and how to turn your book into a business asset. You can find that link in the description too. Now, in my next episode, I'm going to be talking about how to turn your book into a revenue engine. Not just a one-time product, but an asset that generates income for years to come. You don't want to miss it, so subscribe and hit that bell. Remember, you were made to change the world. Now go do it. I'm Ellie Shefi, and I'll see you in the next video.